Major breaking news. The United States Court of Appeals for the Fifth Circuit based in Texas has enjoined the pistol brace rule with respect to the plaintiffs in that case. A lot to break down here. Let's talk about it when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun and constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Disarmed: What the Ukraine War Teaches Americans About Our Right to Bear Arms. Okay, folks, we're going to get right down to it. I just released 2 videos in the last 24 hours. One, a long interview with Stephen Halbrook, the ATF guru, who took down the ATF before the United States Supreme Court. I also did a second video laying out there's 3 cases, or 3 shots, if you will, to enjoin the pistol brace rule from going into effect between now and May 31st. In one of those cases, we've just gotten a ruling, and we're going to talk about that now. And those other 2 cases, and this is why I want you to look at all these 3 videos, because the other video talks about 3 cases, 3 opportunities for us to prevail and shut down the pistol brace rule. We have an answer in one, but just like a slot machine rule, we have 2 other opportunities to win. Okay, first of all, let's talk about the Fifth Circuit ruling here, and then we'll go back to where the other 2 cases stand. Just this morning in the Fifth Circuit, a 3-judge panel in the case of Mock versus Garland. As a reminder, the case of William Mock, Christopher Lewis Firearms Policy Coalition Incorporated, Maxim Defense Industries LLC. They are the plaintiffs in the case, and that's important, and you'll see why. They sued Merrick Garland, the Department of Justice, and federal government to have an injunction against the pistol brace rule, which we're all familiar with. In this order, which I will read to you, the 3-judge order, they've entered an injunction pending the outcome of the appeal to the Fifth Circuit with respect to the plaintiffs in this case. Specifically, this is what the Fifth Circuit says on a per occurring, which means there's not a single author of the opinion. It says, quote, "It is ordered that the appeal is expedited to the next available oral argument calendar," which means it's going to be heard immediately by the Fifth Circuit Court of Appeals. It goes on to say, quote, "It is further ordered," and this is the key, "it is further ordered that appellant's opposed motion for a preliminary injunction pending appeal is granted as to the plaintiffs in this case." So that's very good news if you're a plaintiff in the case, because it has entered an injunction against the pistol brace rule. Now, the plaintiffs sought a nationwide injunction, as I recall, trying to enjoin this rule all across the country. But that was not granted. All that was granted is if you're one of the plaintiffs in this case. Now, the one thing that is, I don't know what the answer is. I'm going to tell you right up front, and I'm not sure that I'm going to be able to give you an answer even if I studied this, is what happens looking at the plaintiffs here. I don't know William Mock, I don't know Christopher Lewis, and I don't know Maxim Defense Industries. And obviously I am familiar with the Firearms Policy Coalition Incorporated, a nonprofit. I am guessing, I have not studied these papers, so I'm being a little hesitant to say this here, but I want to flag the issue. Usually when nonprofits bring lawsuits, they sue on behalf of themselves as the nonprofit, or I should say, a civil rights organization, and they also sue on behalf of their members. So, for example, you would see a case brought by like the National Rifle Association and on behalf of its members. So if there was an injunction in favor of the NRA, arguably, or depending on how it was written, depending on the case, it might say that I, a judge, am entering an injunction against this gun control law on behalf of the NRA as an organization and on behalf of the NRA's members. So what I don't know here, and I'm not sure I can figure out without a lot of work, and I'm not even sure at the end of the day it gives us a clear answer, it is not clear to me from looking at this opinion whether or not any members of the Firearms Policy Coalition would be covered by this order. I also don't even frankly know if the Firearms Policy Coalition Incorporated, which of course I'm quite familiar with because they're litigating all the time, I'm not even sure whether or not they technically have members, although I'm guessing they do. So I only bring this up because there's nothing in this order of an injunction that speaks to members of the Firearms Policy Coalition or members of any of these other, plaintiffs. I don't think these other plaintiffs have members, but if they did. So it's not clear to me if you're a member, for example, of one of these plaintiffs, including FPC, whether or not you would be protected or not under this pistol brace rule. So I just don't know the answer there. I'm flagging the issue. Maybe someone out there will figure it out because I don't know the answer, but I am flagging the issue. Now, is this good or bad news? This is good news, but good news in the sense that obviously the Fifth Circuit thinks there's a problem with this rule. It's obviously for gun owners across the country, by and large, unsatisfactory because you're not covered by this, presumably, because you're not one of those plaintiffs. Now, I should just make a note that there's two other lawsuits pending. One in front of Judge Tipton involving Gun Owners of America and Ken Paxton and the Attorney General of Texas. That's in the Southern District of Texas. That's being litigated. We'll see what happens in that case. There's the same thing. There's a nationwide injunction is being sought. Also, there's a nationwide injunction being sought in the United States District Court for the District of North Dakota. And if you remember, that's on behalf of an organization, I believe, of attorney generals or of states, of a bunch of states. So one wonders whether or not the judge in the District of North Dakota could use this decision today in the mock case to enter an injunction in favor of the states and the attorney generals in that case. And the name of that case in North Dakota, I just picked it up, is Firearms Regulatory Accountability Coalition versus Garland or FRAC. So one wonders whether or not either Judge Tipton in Texas or the judge in North Dakota will take notice of this and enter an injunction the next few days, but we will see. The only other observation I want to make, which is kind of a abstract concept, is I just want people to remember back to the days of the Trump administration during those 4 years where he was trying to fight back against illegal immigration and games associated with immigration and bringing non-Americans to America. And he was trying to enter all sorts of executive orders and try to protect our borders. And we had all these federal district courts continually entering nationwide injunctions trying to thwart the ability of the President of the United States to protect our borders against various involvement of immigration policy or various immigration efforts that he was engaged in. Now, my only observation there is kind of interesting as an observer of the legal system today that the sort of anti-Trump judges, as I saw it, had no problem entering injunctions nationwide on behalf of people that were not Americans. And yet here we are struggling to get injunctions on behalf of American citizens trying to enforce their fundamental right to keep and bear arms under the Second Amendment. To me, that is a strong contrast to nationwide injunctions on behalf of non-Americans who are not American citizens, many of whom allegedly were here illegally or trying to get into the country illegally, and yet there were federal judges out there willing to enter nationwide injunctions to thwart the executive branch, the President of the United States, charged with protecting our borders, trying to thwart him from doing his job in protecting Americans. But again, that is more of a general observation than anything that's specific to the pistol brace rule and the lawsuits going on right now. So, okay, folks, I hope you learned a little bit something here today. I'll keep you abreast as things develop in this pistol brace thing over the next several days. And if you haven't subscribed, please do so, and we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.